going to talk about the Keeping Families Together Parole in Place process. Before we start, just a quick note that this is just information. This should not be construed as legal advice. If you do need legal advice with your case, please contact a qualified immigration attorney. Hi, I'm Stephanie DiPietro, and I'm an immigration attorney. What is parole in place? Parole in place is discretionary power that the Department of Homeland Security has to admit individuals for humanitarian and family unity purposes after the fact. So for many couples, the only thing that's standing in the way of being able to apply for a green card based upon marriage in the United States is that lack of inspection. So under INA 212 D5A, it allows the Department of Homeland Security, when humanitarian and family unity requirements are met, to parole a person in after the fact. Parole in place is granted on a case-by-case basis and is only temporary in nature. Under Keeping Families Together, the parole in place that's being granted is valid for 3 years. What are the eligibility requirements for parole in place under the Keeping Families Together? First, you must be in the United States without inspection and admission. Second of all, you need to have continuous presence in the United States for 10 years. That means dating back to June 17th of 2014. Thirdly, you must be either entered into a marriage with a U.S. citizen or be a stepchild of a marriage of a U.S. citizen, which took place before June 17th, 2024. If it's based on being a stepchild, that marriage needed to have been entered into by your parent and step-parent before you turn the age of 18 years old. Additionally, if an individual has been in proceedings or had any sort of criminal history, you want to look further as to whether you are eligible for this program. And lastly, the individual must not be a risk to the security of the United States, and there must be either humanitarian reasons or family unity reasons for granting the parole in place. Also very important to note, if you are subject to the permanent bar, unfortunately, parole in place is not available for you. How do I apply for parole in place, and what is the cost? The only way to apply for parole in place is online by completing the Form I-131F, and the filing fee is $580. All evidence in support of your application must be filed online. Applications for work authorization based on the parole in place will only be granted after the approval of the 131F. Applicants can apply for the I-130 petition separately to show that it's a bona fide marriage, but an application for a green card, the I-485 application, you must wait until you have the approved I-131F before filing that application, along with the work authorization and the advanced parole that goes with having a pending green card application. What type of documents should I prepare for my parole in place application? First and foremost, you need proof of the identity of the foreign national of the applicant. That may be a copy of his or her driver's license, passport, state or country ID. Second of all, you need proof of the marriage to the U.S. citizen. So that would be the marriage certificate. If either spouse has been married previously, proof of the termination of those marriages. Thirdly, you need proof of your spouse's U.S. citizenship. That may be the biographic page of a U.S. passport, their naturalization certificate, or U.S. birth certificate. In regards to showing your continuous physical presence in the United States for the last 10 years, that can be done through tax returns, bills, anything that places you in the United States and has a date on it can assist you in showing that continuous physical presence. Additionally, in regards to showing humanitarian and family unity grounds for granting your parole, those may be if your spouse, for example, has a medical issue, it may be a letter from their doctor, psychological evaluation, evidence of your country's dangerous country conditions, birth certificates for your children to show that they're U.S. citizens for family unity, if your parents or in-laws are U.S. citizens or green card holders, copies of those identification documents. Additionally, the parole in place application requires at least a 750 character statement in which you have to use at least 750 characters to explain why your parole in place should be granted based on humanitarian grounds and or family unity. You can add up to 2,000 characters to the form. If your statement is going to exceed 2,000 characters, then you can always do an attached document that explains the rest of the reasons why your parole in place should be granted based on humanitarian and or family unity grounds. Am I eligible for Keeping Families Together Parole in Place if I'm in removal proceedings or have already been ordered removed? Yes, while you are eligible to apply for the parole in place, once the parole in place is granted, the process is different for you than for someone who's never been in proceedings or if they've been issued a final removal order. Therefore, it's strongly recommended that you seek the assistance of an immigration attorney if that is your case. If you're applying for parole in place after having been issued a final order of removal, it's important to also provide an explanation of the circumstances surrounding the removal order. Was there a lack of notice about the proceedings? Were you a minor at the time? Did you lack legal counsel during your proceedings? Those are all important factors for immigration to take into consideration when granting parole in place for an individual with a final order of removal. How do criminal convictions and pending criminal cases affect my eligibility to apply for parole in place? All felonies disqualify an applicant from applying for parole in place. If you have a misdemeanor conviction, be prepared to provide a certified criminal disposition. If your criminal proceedings are still pending, your application for parole in place will be denied. So please wait to submit any parole in place applications for cases with pending criminal proceedings until those proceedings have been concluded. I've submitted my parole in place application. Now what? What happens after you submit electronic I-131F to UCIS is that typically an electronic receipt will be issued for you, followed by either a biometric appointment notice or a notice saying that the biometric appointment has been waived. All notices, receipts, appointment notices, approval notices, even requests for further evidence will only come to your electronic MyUCIS account. No notices will be sent to you in this process by mail. Can I have an I-601A provisional waiver and a parole in place application pending at the same time? Yes, you can have both applications pending at the same time. However, once your parole in place is granted and you use that I-94 to apply for a green card, the I-485 being filed triggers the denial of your I-601A provisional waiver because you can't be both eligible to apply for adjustment of status and also be able to pursue a provisional waiver. Therefore, that's something that you're going to have to take into consideration later on, whether if you've been waiting several years for your provisional waiver to be approved, do you want to abandon at that stage for adjustment of status here? Or do you want to continue on with your provisional waiver because perhaps that has been granted and your application for parole in place is still pending? I hope you found the information about the parole in place process helpful. If you have any other questions, please feel free to contact an immigration attorney.